governor who gets a complaint today and issues a show cause same day. In 2020, a resolution is passed saying, obviously your land is acquired, you have to have compensation. But we will give you, as we are giving hundreds of other people, half of the developed land. So 1/4 effectively is the compensation you will get. So this is the land used wrongly. First take half of it, then half of that half developed portion will be given to you, which is what is given to me in 2020. And a sale deed is executed in 2022 in lieu of as compensation was given to me. Now, just Illustration's got the whole facts. In 2024, along come these complainants, fellows, and they select one public servant out of 32 years, 92 till today, who did denotification, who allotted, who invited compensation, who gave compensation, not to me, to hundreds of others. But those hundred of other beneficiaries apart, there must be tens of officers of government who are public servants. This private complaint is born when I am chief minister on events starting 30 years ago, where only one public servant, the chief minister. It reeks of legal balance. On the same day, the governor will issue notice, fellows. Who do I come to, fellows? I can only go to the High Court because there's a friendly governor. And the constitution has been upturned, fellows, completely. Now, on these facts, kindly continue. Come to, fellows, page 347. I am saying this is all discussed by the cabinet. You don't even, fellows, treat the cabinet worth looking at. So, my lord, is 351. Sorry, 346 is a factual matrix. Skip all that, fellows, and come to 351. Got it?
Yes, I am there.
I am doing speed reading, one para only. I'm not
No
reading.
problem.
It is evident from the record that the ownership was changed from so-and-so to so-and-so to Malika Arjun Swami. He's my brother-in-law. All this is happening at a snail's pace over years. Then 355. I'm not hiding anything. Anything I can, when I want to read, I can read. But I'm just narrating. Just 355. 355. The government of Karnataka makes a single member inquiry commission under the Inquiry Commission Act on 14/7/2024.
This is PN Desai.
That's right.
Yes.
To look into it, very well, it's something or the other. They'll report. It's not the end of the matter. Then turn the page, the extracts of the terms of reference are given. Then come to 356. Action has already been initiated. The letters addressed by the Honorable Governor of 5/7 and 15/7 are annexed. A detailed reply. So the governor asked, what are you doing about the so-called Muda scam? The reply is given, the Commission of Inquiry looking into it. So the governor gets the response about good governance, which the elected government thinks fit. Then all those letters are given in para 5.35. Now come to the complainant's part at 357, come relevant to 358. Para 6.2. The crux of the complaint is Parvati has been compensated for having lost her lands without the due process of law. She's my wife, However, in view of the fact that Parvati's constitutional right under 300A has been agreeing to 50, that's the crux of the matter. Then it goes on. They say in 6.3, third line, entire allegations made by Abraham in his petition, even if admitted to be true, do not disclose any offense. So you can tell, the governor can say disclose an offense for this reason. Doesn't deal with it. Then, next page 359. Fourth line, 6.6. The fact of the matter is that pursuant to the alleged family arrangement between the brothers, Mallaraiah transferred the property to Venkatamma. Therefore, the lands have come back to Swami, son of Mallaraiah, and thereby by way of deed of family arrangement recorded in so-and-so. All days are given. The first sentence says, Mr. Abraham is suppressing throughout. It gives all the facts. Then, 362. 6.8. The claim that possession was with Muda is absolutely baseless since no possession notification or Amazar taking over possession is required has been drawn up. Then 364. This talk about, I'll not read all these facts. Lordship will mark 364, 365. Then we also talk of further suppression in 366, in 6.24. We give the things which he has suppressed, the second part of para 6.24. It gives the suppression. And so on. Then come to 376. Then the law on sanction is fully dealt with. 380 tells the Lordships sanction is necessary at the bottom of 380. I hope I'm clear, bottom of 380. Then 384 tells you that the stage for this sanction comes at cognizance, which is not the stage. That is 384.
Right.
I'm very grateful. I'm very grateful.
Yes.
Then 388 tells you the point I'm about to make, that it can be only by a police officer. 8.3. Now, these are reasons. What else the cabinet can do? It can give you every possible reason in law and fact. You deal with it. I'm not saying my main case is you are bound also constitutionally. Forget that for a minute. You're not bound. You to still deal with it. Then now come to what my Lord notes. 218. This is important. At 392. The Sanhita, which is 218, makes it amply clear that the said provision comes into play only at the stage of prosecution and taking cognizance of offences by a competent court of law. Furthermore, the nexus, etc. Then 394 onwards, this exact judgment I have read to your Lordship is cited. 394. And goes on till 397 with Yedurappa. Cited and quoted. My learned friend makes it sound as if I quote the law of the land, I am being frivolous or I am being too detailed. I am quoting the law of the land.
I have never said either of these two.
No. This is my adding color to your colorful expressions.
Yes.
Now, Alice.
I have no, I
now
don't have the
413.
privilege of using colorful expressions.
Now
That's the privilege of a person, Dr. Singhvi, who is both in public life and professional life. I will have to, I can't use adjectives.
Anyway.
Yes.
The timing I let it pass, Malas.
Let's not go on colors.
Yes.
Yes, Malas.
Now, Malas.
Everything is black and white here.
That is correct.
Monochrome.
That is correct, Malas. That's the way it should fall from the judicial side of the organ, Malas. That's absolutely right. Your Lordship is having that in the paperwork.
Yes.
Now, this antecedents, look at Malas, the habitual thing. I'm not saying you could dismiss the complaint of antecedents. Just see the para. We have dealt with it 12.1. We've given facts. Mr. Abraham, history of criminal antecedent.
So we have dealt with means what? You are chief minister.
No, this document which is before the governor has dealt with it.
We have dealt with it.
Therefore. Yes.
Chief minister has not dealt with.
I hope the best. My learned friend has made two best arguments till now.
No, the truth has a strange way of coming out.
Best arguments are, first is, I am the governor, give me time. Second is that this document should not have the word we. I can't divorce myself from the fact that I am the chief minister, elected one of the state.
No, this is
and this is a document of the sanction.
No, this is reply by the chief minister.
No. This is I'm saying
cabinet note.
Decision
so
of the
I'm
cabinet.
saying, my learned friend is saying, well, just see the antecedents. Just see antecedents.
Yes.
Is it not relevant for the honorable governor to have seen this?
The word.
They pointed out that he was a habitual blackmailer and court bird with history. Supreme Court has strictured him. I've quoted that in terms of the document I'm reading, not that I have drafted the document.
That may not be relevant for a decision.
Yes, that's all right.
Whether there is application of mind or not.
Now, this is very serious.
Yes.
The cabinet finds it to be selective Article 14 discriminatory arbitrary treatment by the governor. See that, para 13.3. That's a separate point by me. Just read this very, very important one.
Yes.
The selective treatment of Abraham's petition, same day. Given the governor's inaction on numerous other pending petitions, such as proposal for prior approval under 17A, against nominal, every detail is given. Shashikala Jolie, dated 2021. Supersonic speed, same day versus 2021, 3 years ago. 3 years ago. The proposal dated 26th February 24, Murugesharani. That is 6 months ago. Janardhan Reddy. These facts strongly suggest that extraneous factors influence the governor's decision. The Supreme Court has emphasized that actions based on extraneous, etc., Bombay political vendetta. And then, Malas, the final advice is at 420. I would say, Malas, whether appropriate to one side or the other, the page number is appropriate. Now this page number is also gone in the new sign.
No, no,
Now
that's what I was telling when
Now
I
the page
was
number is
holding.
gone in the new sign.
The biggest change in, they said, no,
Gone.
there is
It's
no
gone.
change. The biggest change is 420 is gone.
It's a psychological
Cheating
change.
is gone in BNS.
But fellas, may I say, 420 was never a section. 420 was a metaphor, always.
Yes, that metaphor is no longer in existence
You also
because,
remember the very old Bollywood
it-
film in black and white?
yes, Sri 420, that is also
So
gone.
it was a metaphor, fellas. That metaphor will always remain, whether you have
Metaphor
many
will
signs.
remain,
That's right.
But 420 goes away.
That's right.
Yes.
So now the final order is the Honorable Governor ought to have, under the present set of facts, acted only on the advice and aid, not in his discretion. While proceeding to issue show cause, failed to consider the material available, ought to have taken into consideration the reply submitted by Chief Secretary on 26/7, received by the Governor at 6:30. Chief Secretary inter alia highlighted the direction, constitution of Judicial Commission, etc., etc. And then, all these reasons are given, and finally said that you are obliged to. As far as I am concerned, I've separately filed a reply.
No, that
I have
is-
not said that, look, I'll not file reply because you are acting without jurisdiction, which you are. But without prejudice, I filed a reply, detailed reply. He has not considered that. Some of your lordships can add to the fact he does not consider the cabinet's note. He does not consider my reply. Obviously, they will overlap in terms of content, but in terms of substance. Now, let me come to so this is the one major point, fellas, in terms of the proposition. I go to the next one immediately is, you as the governor are acting in a judicial reviewable capacity in granting or not granting approval, which my lord actually rightly and pithily summarizes as 17A/218. What you say is judicially reviewable on the standard classic grounds of relevant considerations, extraneous considerations, Wednesbury reasonableness, eschewing this thing or that thing, etc., etc. Lordship knows that well. Forget that. My lord doesn't have to do that exercise. My humble and respectful submission is there is nothing. Your lordship read the order. Your lordship will do the exercise of Wednesbury reasonable after you see some reasons. The only sole reason is I am not bound by your advice. Hence, sanction or permission or approval. This is proposition 1 with the 2 judgments. The second is 17A, my lord, read in the order. Now just note 2 or 3 things. Just take 17A. I'll just be very brief once. 17A. I don't have to read any case law, though there are many. The section makes it clear. PC Act 17 capital A, as the lordship knows well, came in 2018, July 2018.
Yes, 26/7.
No police officer shall conduct, and it starts with that.
Yes.
No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant. So alleged to have been committed by a public servant, where the alleged offence is relatable to any. Now just look at the. Are you not violating the legislative intent patently? Just give me a second. Put a full stop after the word act on the 3rd line. They limit. They don't put a full stop. They add a suffix. No police officer shall conduct, but additionally, even if he conducts, suppose if it's a non-police officer, the first condition goes, you can't do it. There is no police officer here as a complainant. Second condition is supra-added.
Not yet.
Yeah, that's right.
Not yet a police officer.
Not yet. That's correct. No, we are talking of now the 17A stage, which is mentioned in the order. We are talking of that order. What will happen later is different. Now, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge, as my lord noted, of his official. Now, from 92 to 22, the file never came to me in any capacity. So neither decision nor recommendation. What you are really confusing is with an alleged beneficiary to constitute, sir. So you can't violate the section like that, on the face of it. You cannot violate the language of the section. Now, please see. This is still granted. Despite that, there are 3 judgments, your lordship and note, Sri Rupa, I believe it is
all are mine.
My lord judgment.
All 3 you have cited are mine.
I always am very hesitant to cite a case authored by the same judge before whom I am arguing. I appeared many moons ago. I have told this to many people in Supreme Court, and my learned friend has heard it also.
I saw the index, and all 3 judgments are mine.
So I am grateful, your lordship knows it well. Lordship will not have the citation. Give it to my learned friend, please. Kindly hand it over to him.
Yes.
I was telling your lordship the slight aside, which I have told my learned friend many times in Supreme Court also. I was arguing a matter before Justice Chinnappa Reddy. And Justice Chinnappa Reddy, I came across 3 decades ago. I cited a case on all fours in my favor. And it was authored by him as High Court, Andhra Pradesh judge. So afterwards, he had a very twinkle in his eye and a sense of humor. So after 2 minutes, he says, but Dr. Singh, you did not realize that I was waiting for a chance to overrule myself. So I am sure your lordship is not waiting for that chance. Each of these three judgments, may I save time? It's not to be brushed aside.
It's on application of mind.
No, your lordship has given reasons.
Yes, I have reasons.
It can't be just ignored, Malas. I mean, I can understand there's a contrary division bench of Karnataka, there's a contrary Supreme Court. How can there be a contrary Supreme Court of what your lordship has written, Malas? With great
I
respect.
don't know if Supreme Court has written.
No,
something
on
else.
this point, there can't be, Malas. What has your lordship said? My lord has said that on 17A, the conditions precedent of the sections have to be, the mind has to be applied. Mind will be applied to what, Malas? To the condition precedent of the section, obviously. So this is not something which, Malas, it can be overruled. Your lordship has applied the law. And all three judgments, lordship remember, Sri Rupa, Dr. Ashok V, and Praveen Kumar.
Yes.
3 judgments. Your lordship has got the para, may I? Malas?
First one was Praveen Kumar.
Yes.
Gulbarga-
Praveen is
Gulbargi.
14 to 16 para numbers. And Malas, the others are 23 to 28 is
Yes,
that
yes.
Sri Rupa. But my lord knows this. So you give the pages to him on the compilation. Otherwise, I don't want
It's
to
here,
Malas,
sir. I'll
repeat
go
it.
through it.
Now, note 2 more things, Malas, on 17. So first point on 17A is conditions precedent of section. Number 2, your lordship's judgment. Number 3, there are 2 circulars about criminal law approach and investigation under 17A. One circular is by the High Court of Karnataka. Just
That
tell
is
me.
after judgment in JV Ashok.
I'm grateful.
Yes.
So one is that, Malas, at 260 of the paper book. Just note that.
Given that.
And there is
circular-
one by the central government, a SOP. Once again.
Which is the central.
First one is 260, just for 15 seconds, just pause it that, Malas.
260.
Yes, that is 23rd September 2023.
Volume 2.
Huh? Volume 2.
Petition. Writ petition.
The writ petition, no, not the law, Malas, not the law compilation, the main writ petition file.
Page?
They're not them.
No, please. First is 260. I'm on the High Court of Karnataka circular.
260.
I emphasize it is mandatory. Please follow it
No,
strictly.
this is
That's
after
all.
Dr. Ashok's.
That's right. So I'm just pointing out the circular 260 of the paper book. Now the second one is 703, which is the last page document which my learned friend was saying. On 3rd September 2021. 703.
Yes.
And the last 3 paras of that are relevant, which are paras 2, 3, and 4 at page 704. So as to standardize and operationalize procedures with a view to achieving uniform and effective implementation for prior approval processes, a set of SOPs are hereby conveyed. The SOPs provide for stage-wise processing of information received by a police officer, specify the rank of police officer to seek prior approval under section 17A. Considering the proposal under 17A by the appropriate government or authority, laying down a single window. Well, if the condition because section is not looked at, so where is the question of doing all this? All administrative authorities, including ministries and departments of central and state governments and IAs, investigating agencies, are requested to take note of the SOP as appended herewith, bring to the notice of all concerned, etc., etc. So I've done 3 points. Natural justice is clear. The first point was name of Mr. Abraham. Actual order has 2 more. Those 2 more never supplied to me. The order is based on those 2 also. Second point is he does not discuss or give any reason. Third point is 17A. Fourth point is 218. Can you turn to 218? What is the point here, Malas? At page 47, the learned governor grants Malas an order which invokes 218 of the Sanhita at page 47.
Yes, I am there.
Right, Malas? Now, Lordship knows in pari materia 2197 and all that. Now, the language of 218 itself makes it clear that it has to be offense specific, ingredient specific.
Yes.
Resistance to taking of property by lawful authority of a public servant. Whoever offers any resistance to taking of any property by the lawful authority of any public servant, knowing or having reason to believe that he is such public servant. So knowledge is important, one is mens rea. Such shall be punished with either description. But suppose I go to somebody and say, you're guilty of 218, you're guilty of 218. 218 is not an end in itself, Malas. You have to show what 218, what ingredient, what offense, how. How is important. See page 47. Lordship find nothing. Page 47 is nothing. It says exactly what I'm saying. 218. There may be other points I'm not arguing now on that point that 218 came now. This offense relates to when.
Since
But that's all right. I'm not, your Lordship will have to see whether it applies back or
it's
not.
taught after BNSS and being granted, it is only BNSS.
I am not even arguing that for the time being.
Yes,
I don't
that's
want to get into that. Now, there's two more things that I'm done. One is, the larger issue of selectivity of these 4 other complaints, which my lord has noted that one page of the cabinet
That I
decision.
have seen. Let them all file their
Names are given.
objections.
Names are given there. Details
No.
are given.
Let the respondents file their objections if they want to.
That's right. If they say that, look, for this reason, I could not decide a 2021 complaint, but I decided yours on the
So
same day.
let the, even the
So, Manoj, I am saying,
SG is representing the
My
governor.
instructions are there are no sanctions pending.
let me end.
Yes.
Let me just end. Please allow me to finish. Manoj, one thing which is larger issue, not today, but Lordship should know the flavor of it. Just turn to 155 para number of Navam Rebia. I'll be very brief because
155.
para number. Now, I hope we get it correct this time.
Page
869. Turning it in 78.
Huh. Para 155.
Now, 155, that your lordship's 1027.
Summarize our conclusions.
Right. Firstly, Constitutional Bench is summarizing the measure of the discretionary power of the governor. So there's no point, my learned friend, just for us flushing it aside by saying, oh, it's a 10th schedule case. It's a 10th schedule case which arose in the context of an intersection with the governor. The governor tried to interfere. The court said, you stay put within 163.
Yeah.
Directly arose. So, my learned friends, brothers,
So
and
here, sanction has to be accorded by the governor only.
correct. No,
get-
we are not
him
on the
being
governor.
found by the advice of the Council of Ministers
Where
would not.
Where the chief minister is no party of the decision-making process.
That will consider.
That's
Yes.
now let's just see. Firstly, I think this point for a minute I'm assuming against myself. I'm just
Yes.
putting it because I opened with the other point.
Yes.
But I'm just putting it for 2 minutes and ending on that. The measure of the discretionary power of the governor is limited to the scope under 163(1). Now, 163(1) doesn't say that you can say blanket the entire cabinet is disabled because the chief minister is involved and he appointed you all. You can't say that. That's too general. Then, Malas, all the cases your lordship has of conflict of interest are where I'm in some way directly myself deciding my case. It's not this case. Then, Malas, secondly, under 163, the discretionary power extends to situation where a constitutional provision expressly requires the governor to act in his own discretion. Expressly. None. Thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from a legitimate interpretation of the provisions concerned, and the same cannot be construed otherwise. Fourthly, in situations where this court has declared, sometimes a lordship says you shall decide. That is not this case. And lastly, Malas, fifthly, about 163(2), final and beyond the scope of judicial review, answer no. Answer no. Now, Malas, two things I've done here. I have read to your lordship the last word of a constitution bench. I have read to your lordship 163, which is directly relevant to the governor's powers on the larger issue, not argument. Just one thing and I end, Malas. Just to tell your lordship why my infants, instructions are wrong on this. Note this, that MP police judgment, which is in your lordship's file at page.
Yes.
Just note these paras. This lordship may note because it will be difficult to
242.
find out. Yes.
No, 262.
But just note these paras.
Yes, that's all right.
No, I'm sorry. My apologies. I meant something else. The paras of Navam Rebia, which deal with MP establishment, those paras.
Which is that?
Para 116. Lordship will note the para. Lordship will see it later on because it's not being argued now.
Yes.
So clearly, Navam Rebia will govern, not MP. The governor cites only MP. Now see those paras. 116, 118, and 118 may be ticked by lordships in particular. I'm emphasizing it. 128.
This is exactly the point. There was a case where governor had to act or was required to act on the aid and advice of the Council of Ministers because he is not acting on his own. Now here is a case where sanction has to be accorded by him acting on his own with application of mind is imperative. Yes, that you may say.
Very well, I
But
will.
according this judgment may not be
No,
prima
why
facie.
not, my lord, therefore I'm saying, I'm only saying Nabam Rebia and MP will be considered at final hearing in some form as to how much of
That
MP
will-
remain. That's all I'm saying. Let me not argue it now.
Because what was imperative in there and imperativeness
Yes.
here are totally different.
Now, well,
Playing
I
the role
bow
of the
down.
governor.
I bow down to that.
Yes.
Well, lastly, two things. First and foremost, fellas, the governor is a person who has spoken in his order. If I don't make him a formal party, we make even tribunals a party frequently, but they don't necessarily, he cannot have an interest in your lordship granting me or not granting me interim protection.
That will.
No,
will
I'm
answer
just
it.
pointing out, fellas,
Yes.
because it's easy that I'm a governor, I've come, therefore give me. I'm saying he may be there. He may come and deal with it, but he can't be personally interested in expanding, rewriting or supporting his order beyond Malas, the interim stay which one is seeking today. Number one. Number two, it would be very odd for a governor to do that. It will validate my Malas point. Number two, it is clear that the matter is before the court tomorrow. Now, Malas, you will have cognizance, you will have pre-cognizance and post-cognizance actions. The whole idea is to then start a process to Malas undermine and destabilize the government. Number three, it is also Malas, constitutional law, law and politics are intertwined. We are not Malas, we don't live in some ivory tower, cloud cuckoo land. Malas. Your lordship is not in a that when a storm is coming, so I'm a ostrich, so I put my head in the sand. That's not the way Malas judges function. So immediately then Malas, a whole process starts clamoring. There is of course nothing in law short of a conviction which affects your resignation. But the idea is why start a process which is on the face of it, Malas, 1992, 2024, today you go to the governor same day issue show cause, within 2 weeks, we are Malas less than, let's say 1 month. And he must, Malas, your lordship, on what balance of convenience must there not be a status quo ante as of Malas prior to the order of the governor's order? On what basis? If heavens have not fallen from then to now, and Malas, on what basis will the day, 1 day before the order of the governor, not be a valid balancing of equities, not be a valid irreversible consequence test, not be a valid balance of convenience test? And governor, Malas, just because of stature, should in fact keep away more aloof. He should not be saying why no stay.
Anybody has to reply, we will see.
My lord, only 5 minutes, my lord, because I have yet to go through it, my lord, but I have
Go
an
through the papers,
answer.
file your objections.
My lord,
All of
I
you
have
who are
only,
respondents, let them come up with objections.
yes, certainly, my lord. My lord,
Detailed
only
objections.
few facts, my lord,
Yes.
without going into the merits, my lord, because my
Yes.
learned friend said something, and we have an answer, my lord, in law of everything, my lord. I represent the governor, the office of the governor, and therefore, my lord, I do not have the luxury of, my lord, using adjectives like friendly governor, etc., because it would not be in good taste. Suppose I also start saying subservient cabinet or a corrupt chief minister, doesn't look good because all are constitutional functionaries, and irrespective of the party position in the petition, whether we are petitioner or respondent, we must respect the constitutional office. Lord, the three questions, my lord, which I'll have to answer, my lord, first would be the power of the governor in granting sanction under 17A vis-a-vis the cabinet decision. I'll be able to show para to para, page to page, cabinet decision and the pages of the petition, verbatim saying, if cabinet decision is first, then it's okay. Then, my lord, the person who has drafted the petition is guilty of plagiarism. But if the draftsman is same, then the cabinet is guilty of non-application of mine. But that's, my lord, on facts. In law, MP, my lord, governs the field, and MP judgment, my lord, clearly only, my lord, one paragraph, if your lordship permits me to cite, my lord, concludes the issue, my lord, so far as the constitutional position is concerned. My lord, please come to, my lord, that MP judgment. I don't have, my lord, my learned friend's compilation, But MP judgment, para 14.
I've not even argued for time being, but I've not even argued. I started, I left it there.
Para 14. Mr.
Yes.
Dr. Singhvi, you argued for 2 hours. Give me few minutes.
Yes, sir.
I'll confine to the constitution and not any spicy expressions for media. But please see para 14.
Yes, sir.
As has been mentioned above, your lordship gets, my lord.
In
Lord, MP Special Police Establishment versus State of
That's-
MP.
225.
Yes, no, it's a constitution bench judgment where precise question was the power or responsibility of the governor while granting sanction, whether he is bound by the cabinet decision or not, whether aid and advice of the cabinet would be binding on the governor or not. Para 14 starts, my lord. I am not reading the entire judgment at this stage. My lord, I'll
Yes.
assist your lordship, my lord.
Yes.
But your lordship may not find that
Lord,
judgment.
14, my lord.
Where do I?
Copy, you can give a copy. My learned friend is giving a copy.
14 and 19, my lord, 2 paragraphs. My lord, that summarizes the law. And my lord, whoever has prepared the cabinet note, my lord, has relied upon this, unfortunately, forgetting that their counsel would come and dispute that by citing Nabam Rabia, which is completely irrelevant for present case. 14, your lordship gets, my lord.
Yes, I'm there, sir.
As has been mentioned above, the division bench had noted this case. The division bench, however, held that even though this principle may apply to the case of chief minister, it cannot apply to a case where ministers are sought to be prosecuted. We are unable to appreciate the subtle distinction sought to be made by the division bench. The question in such cases would not be whether they would be biased. The question would be whether there is a reasonable ground for believing that there is likelihood of apparent bias. Actual bias only would lead to automatic disqualification where the decision maker is shown to have an interest in the outcome of the case. Principle of real likelihood of bias has now taken a tilt of real danger of bias and suspicion of bias. Now, please come to my lord 19. They are saying
Yes, sir.
when the cabinet is deciding about the minister or a chief minister, what will be the contours of the power of the governor?
Yes.
Para 19, my lord.
Yes, sir.
Article 163 has been extracted above, undoubtedly in a matter of grant of sanction to prosecute. Governor is normally required to act on aid and advice of the Council of Ministers and not in his discretion. However, an exception may arise while considering grant of sanction to prosecute a chief minister or a minister where, as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the Council of Ministers disables itself or disentitles itself. Mr. So-and-so on behalf of ministers submitted that the case of chief minister would be completely different from the ministers. He submitted, my lord, not relevant. My lord, court says no. It applies to both, and there would be an apparent likelihood of bias if the cabinet decides, because the cabinet is appointed on the aid and advice of the chief minister by the governor. And para 32, my lord, of this judgment. On these facts and circumstances, the governor cannot act in his own discretion. There would be a complete background of rule of law, etc., etc. There was material before him, prima facie, etc. The second question, which I'll deal with, my learned friend's contention that the governor has not dealt with, parawise or otherwise, the decision taken by the cabinet notes. There are twofold answers. Answer on facts. The cabinet, the governor has taken a view that the cabinet's decision is not binding on me based upon the principle of law laid down in the 5 judges case. And therefore, there is no question for me to examine whether it is right on merits or not, because it has no jurisdiction. Second, and without prejudice to the first, there are judgments to the effect that even while acting on the aid and advice, the governor cannot sit in appeal over the decision. He is not an appellate authority who will, my lord, go into the matter. I'm sorry. go into the merits of the case. My lord, your lordship's judgments on, my lord, only police can seek approval and not, my lord, that helps, my lord, that assists, my lord, your lordships again, my lord, for the facts of the case. But it's a reasoned order passed on file. I'll place it on record. And whatever, my lord, constitutional position, I'll assist your lordships.
All right.
I would request, my lord, any date, my lord,
We will,
because
Yes.
once, my lord, the governor, who is a constitutional functionary, has granted sanction, lord, injunction of any kind, whether direct or indirect, by another constitutional
No,
body
true,
may be
but,
avoided. That's all.
the submission, we have to hear and readings have to get complete. The
Yes,
submission
yes.
is that the matter is tomorrow. This should not be rendered fait accompli by any action taken by the concerned court.
Lord, unfortunately, in our legal
all.
system, nothing happens in a day in a court of law, my lord. My learned friend can, my lord.
Act on the sanction, but they can't act.
Yeah, that's right.
Because, my lord, indirectly also,
We'll,
the lordships
we'll
would be
post it
very-
day after tomorrow or Thursday, whichever day you
Thursday,
want.
my lord, Thursday,
Thursday.
my lord. We'll
We'll
file
post
on
it Thursday.
Day after.
Let not the court proceed further till Thursday.
That's all.
My lord, they can seek time, my lord. I mean, there are ways and ways, doctor.